Good morning, everybody. Happy Friday to you. It's Dave Neal, stand-up comic, host of the Rush Hour podcast, and I'm going to read for you guys the new court filings by Blake Lively. This is a nice Friday treat for us. Going to get into all of this. It's only 21 pages long, but as you know, this can add up in time, so let's dive right in. This is the reply in support of defendant Blake Lively's motion to dismiss the amended complaint. She's like, I want to get out of here. And then Justin Baldoni's side is like, no, you don't. And then her response is, but I do. That's where they're at. So she's going to make some pretty bombshell accusations. She's going to throw some elbows at Justin Baldoni, use his words against him, all the good stuff. And it's going to get ugly. Now, of course, the judge isn't going to dismiss her from this case, but a girl can dream. Let's dive right. And by the way, I did cover the first page of this in the Morning Rush Hour podcast. But of course, the Morning Rush Hour podcast, I have to cover an eclectic amount of content. So I only share that. And this is for those of you that wanted the full version. Now, just so you guys know, I mean, I'm drinking my throat tea over here. I've got a whole system set up to keep my voice from not going away, but we'll have to see how that goes. So don't mind the tea slurping. Anyway, let's get into it. Introduction. The Wayfair parties have tied themselves in knots trying to state a defamation claim against Miss Lively that is not barred by the statute of limitations or wholly contained within her legal complaints, which they concede cannot form the basis of any actionable claims. They have been entirely unsuccessful. As a result, the Wayfair parties have hit the do-over button again, reinventing their complaint to apply only to alleged statements from July to December of 2024, before Miss Lively filed her CRD complaint. If true, then the elaborate tale the Wayfair parties tell in their 391-plus paragraph complaint is largely irrelevant because, according to them, nothing that happened before July of 2024, including the production in the cut of the film, is part of their defamation case. They have essentially admitted that their $400 million lawsuit was a PR stunt. The Wayfair parties do not appear to understand the implications of their own concessions. Remarkably, the opposition continues to rely upon allegations they claim are not part of the case. The opposition's discussion on actual malice, for example, is based entirely on the complaint's effort to dismantle, point by point, the insinuations in the November 2023 17-point list, as well as the complaint's tired narrative that Miss Lively fabricated, materially mischaracterized, or grossly exaggerated all of the allegations she made in her CRD complaint and federal lawsuit. But because the Wayfair parties argue that they are not relying upon, one, any alleged statements prior to July 2024, which would exclude the 17-point list, or two, the legal complaints, which they agree are privileged, neither of these can support the element of actual malice. Moreover, the Wayfair parties once again focus on Baldoni's insistence that he believes he acted appropriately, rather than point to any facts indicating that Miss Lively subjectively doubted the truth of her alleged statements, whatever they are, and they ignore the plethora of evidence in their own pleading that demonstrates her unwavering good faith. Oh, Blake Lively's actually got good faith. Oh, I guess we should dismiss this. I'm going to lean back, guys. Unable to identify any actionable statements by Miss Lively, they argue she is liable for things her husband allegedly said. In 2025, the good Lord's year, wives are not responsible for their husband's words. It is incredible that Baldoni, a person who calls himself a quote-unquote feminist, would take such a position. So they invoke the old self-proclaimed feminist label against him. Boy, they're really going to be pulling at the old man bun here. Let's see if it gets any worse. This is just the intro. Realizing that a loss of the defamation claim subjects them to attorney's fees, treble damages, and punitive damages under Section 47.1, they attack that provision on constitutional grounds, which is an attack on all victims of harassment and assault. Fortunately, the Wayfair party's effort to invalidate California's duly enacted legislation is frivolous. The First Amendment empowers legislators to protect victims' First Amendment rights via fee-shifting rules designed to deter retaliatory litigation. In addition, the opposition fails to address the many other defects that require dismissal with prejudice. The Wayfair parties failed to allege specific monetary harm. Do not dispute that each claim is rooted in defamation, thus all fail. 3, ignore California authority upending their extortion claim. 4, improperly plead new facts in the opposition to cure the obvious defects in their breach of covenant claim, which still fails. And 5, fail to articulate the key elements of both tortious interference, including a duty of care supporting negligence, and conspiracy, the critical meeting of the minds. Last but not least, the opposition ignores that the scattershot group pleading does not allege any facts at all related to most of the plaintiffs, yet asserts all these claims on behalf of them, all collectively. The meritless complaint is a classic case of retaliatory litigation, cannot be saved by amendment, and should be dismissed with prejudice. And in the subheading here, the opposition concedes by silence that the following do not apply to certain parties: civil extortion, no allegations as to Abel, Nathan, or Sarowitz, breach of the implied, and so they go into all the different thoughts there. Pretty wild stuff, right? I mean, I don't know. We read this and we go, ooh, this sounds good, is it? Well, what do we know? I mean, the fact that they're, is it true that Blake Lively's saying they're not going to bring in the 17-point claim, All right. Juiced up. Argument. The Wayfair party's desperate attempt to reframe the defamation claim fails to save it. In their new telling of the case, the Wayfair parties now state that rather than the complaint boiling down to 2 categories of publication, as they urged in their oppositions to the Sloan parties in the Times motion, they seek to hold Ms. Lively liable for 3 publications, 2 of which do not even involve her. 1, Mr. Reynolds' supposed comment to WME that Baldoni is a predator, the predator statements. 2, the Sloan party's alleged statement that Baldoni assaulted Miss Lively, the Sloan statement. And 3, Miss Lively, Mr. Reynolds, and the Sloan party's alleged unidentified statements to third parties, including the Times and other outlets, to the effect that the Wayfair parties engaged in, permitted, and or failed to prevent inappropriate conduct towards Lively and others and retaliated against Lively, the media statements. None of these is sufficient. Now, I believe Baldoni's side argued that she was liable for what Ryan Reynolds said because he was acting as her agent. Now, I know he wasn't really her agent, but the fact, anyway, I don't know. We'll have to see if they make that claim. The opposition fails to show that Miss Lively is independently liable for defamation for her own alleged statements. The closest the Wayfair parties come to a specific statement is arguing that Miss Lively falsely claimed to the Times or other media outlets that 1, the Wayfair parties had engaged in an insidious PR sabotage operation deployed as revenge for harassment complaints, and 2, the protections for return to production were proof positive that harassment was endemic on the film set. Each purported statement is insufficient. And by the way, I think if you're Baldoni's side, now obviously you want to win everything, but if you're Baldoni's side, I think at the very least you would just be happy if maybe not winning this side of the case, but you were exonerated and it was proven in court that you weren't what Blake claimed you to be. So again, I don't know what that looks like, but if part of some of these claims are dropped or dismissed by the judge, that doesn't, in the end, I think the most important thing, other than obviously there's a lot of money on the line, I think the most important thing is restoring your name in the public eye, right? The protections for return to production complaint does not allege that Miss Lively told the Times prior to filing her complaint that the protections were proof she had been harassed, which is fatal to this new theory. And even if it did, such a statement would not be defamatory. A statement regarding what a document supposedly proves is unactionable opinion. Also, the Times publication themselves make only passing references to the protections. They do not state or even suggest that the protections prove harassment occurred on set. Instead, the only publication that plausibly suggests the protections prove harassment is the CRD complaint, which the Wayfair parties concede is both privileged and not a basis for their defamation claim. That's so crazy that it's privileged, and yet it can be used for the New York Times to then write an article, They really, it really feels like Baldoni's just like, what are you supposed to do, What are you supposed to do here? And they got all the money in the world, and it still seems like this might, not even, this aspect might not even go to trial. Moreover, the Single Publication Act bars any claim based on Miss Lively's alleged statements related to the protections, no matter to whom or in what form she made them, because they were first published before January 17th, 2024. The complaint is explicit that as of 2023, Wayfair found the stunning list of protections unsettling, believed it misrepresented set culture, attempted to revise it, and concluded that it had been drafted for the apparent purpose of insinuating or outright claiming that Baldoni, Heath, and others had engaged in inappropriate conduct during filming. In fact, in arguing malice, the opposition identifies 8 bullet points that track the protections. Rather than confront the Single Publication Act, the Wayfair parties ignore it. They assert the earliest statements at issue were made in or after July 2024, at 20, but do not identify what Miss Lively supposedly said, when she said it, or to whom, utterly failing to establish the necessary elements of specificity. They do not even attempt to explain how Miss Lively's insinuations in November of 2023 differ from the supposed 2024 statements at all, much less how the latter are timely. By failing to address that issue, the Wayfair parties abandon any argument to the contrary. The false and insidious story, the allegations that before filing the complaint, Miss Lively told the Times a false story that the Wayfair parties retaliated against her similarly fails. The Wayfair parties do not identify any statements at all, much less statements either specific enough to enable Miss Lively to defend herself or ones that are not wholly contained within the legal complaints and therefore privileged. The Wayfair parties cannot evade the privileges. The opposition fails to rebut the application of the Fair Report, litigation, and sexual harassment privileges, all of which bar the defamation claims. Fair Report privilege. The Wayfair parties rest their challenge to the Fair Report privilege on timing, insisting that Miss Lively secretly collaborated with the Times for months before the filing the complaint, attempting to distinguish between 2 levels of statements, Miss Lively to the Times and the Times to the public. But discussing legal claims with a news outlet before filing them does not vitiate the privilege. November 25th, 2024, we do not believe the timing is or should be dispositive so long as they were fair and true reports of the allegations in the filed complaint. Indeed, to subject people to liability for fair and true reports to the media just because they were made in anticipation of a lawsuit that was actually filed rather than after it was filed would frustrate the purpose of the privilege. So what they're saying is just because Blake colluded with the New York Times for months beforehand doesn't mean they did anything wrong here. And again, this is that type of thing where sure, this may play in court, but I don't think this helps her PR at all. I don't think this changes anyone's minds. Regardless of when or how information was communicated to the Times publications are confined to a report of the complaint, lifting it nearly verbatim. Lively's alleged state, but again, also, Lively never served that complaint to the Wayfair parties. Lively's alleged statements regarding the protections in the sabotage operation are inextricably linked to the gravamen of her filed legal claims. As such, the Wayfair parties failed to identify what harm, if any, Miss Lively's identical alleged pre-filing statements to the Times caused. Instead, the Wayfair parties have been crystal clear that the article is the genesis of the entire action, and that their supposed $400 million in damages stems directly from what the Times actually published after Miss Lively filed, which falls squarely within the protections of the Fair Report privilege. The litigation privilege, because the Wayfair parties failed to identify a single statement by Miss Lively outside the legal complaints, the litigation privileges bar the defamation claim. The Wayfair parties' baffling argument that Miss Lively did not seriously consider litigation because she waited to file suit for 11 days after receiving a right to sue notice is meritless. In any event, didn't they make that claim? They were like, this can't be real because she's not going to sue. And then the next day she sues something. They're like, oh boy. In any event, Miss Lively was not required to request a complaint, investigate her claims, or to simultaneously file civil litigation. Further, the Wayfair parties concede by silence that the litigation privilege would apply to the CRD complaint even if Miss Lively never filed civil litigation. harassment privilege. The Wayfair parties accept by their silence that Ms. Lively's statements constitute communications regarding an incident of assault, harassment, or discrimination. It protects Ms. Lively's statements to anyone, and that Ms. Lively needs not have actual complaint for the privilege to attach. They advance two challenges: that Ms. Lively made her statements without a reasonable basis and with malice. Both fail. First, the complaint itself shows Ms. Lively had a reasonable basis to complain about harassment and retaliation, which is all that is required. The complaint's admission of a harassing incident while on set. Text from Nathan: you know we can bury anyone. Reports of HR complaints, among others. The Wayfair parties quibbling with Ms. Lively's characterization of the events that they admit occurred and she raised in real time does not undermine her reasonable basis, nor does the Wayfair parties' narrative that Ms. Lively allegedly inserted herself into the production process, which concerns statements they admit do not support liability, and that are nonetheless irrelevant to Ms. Lively's harassment concerns. The same analysis applies to statements concerning the protections and the insinuations therein, which are time-barred. Second, the parties agreed that the actual malice standard required an allegation that Ms. Lively made knowingly false statements or acted with reckless disregard of the truth. The Wayfair parties are unable to defend the complaint against this standard and fall back to the same strategy that plagues the complaint, generally referring to Ms. Lively's accusations without identifying any specific one and flatly concluding they are all false without explanation. But that fails to establish malice. They get into the case law there. Baldoni and Nathan stated in writing that Ms. Lively genuinely believes she's right and that all of this is unjust. As for retaliation, they claim that their texts disprove a smear campaign and that Ms. Lively's own alleged malice is established by the inherent improbability of an untraceable campaign. But the plain language of those communications, in their own words, contradicts such arguments. The only reasonable conclusion is Ms. Lively wholeheartedly believes in the existence of a smear campaign. Ms. Lively is not, and I can believe that it might be delusional, but I can believe that Blake Lively believes that there was a smear campaign. Because even though my personal belief is that they never had to enact a smear campaign because the internet was doing its thing on its own, that's my belief. But I believe that Blake Lively doesn't believe that. Miss Lively is not liable for statements that she did not make. Miss Lively is not liable for her husband's alleged statements. And another stunning example of Baldoni's faux feminism. Oh, here we go. Faux feminism. He argues that a wife should be liable for her husband's statements. Fortunately, that is not the law today. So they're really coming after him. Faux feminism. That would be like a good podcast. Joining us now on Faux Feminism. To begin with, Miss Lively cannot be liable for statements made by Mr. Reynolds that, as a matter of law, are inactionable. So they have the case law there. There's no basis for vicarious liability if there's no underlying liability in the first place. Even if the predator statements or any others were defamatory, that being by Ryan Reynolds, the complaint fails to plausibly allege that Miss Lively played a responsible part in their publication. It is also devoid of allegations that Mr. Reynolds acted as Miss Lively's agent. All right, so there's the argument. That was the argument that Baldoni side made, that said basically Mr. Reynolds is her agent because he was talking to other agents. The Wayfair parties argue that Mr. Reynolds represented Miss Lively in dealings with WME and others and acted as her representative in dealings with Wayfair and Sony. But they ignore their own pleadings, acknowledging that Mr. Reynolds has his own relationship with WME and his own reasons for communicating with it. That he is alleged to have spoken to WME is not sufficient to infer he acted as Miss Lively's agent in doing so, and the Wayfair parties have cited no authority to that effect. Yeah, but he was talking to WME to get them to dump Baldoni because his wife told him that he was a predator. They also failed to explain how Mr. Reynolds attending a single meeting with Miss Lively for support creates an agency relationship for all other purposes. The law is clear that agency cannot be implied from the marriage relationship alone. Further, while insisting that Miss Lively ratified and made the predator statements her own, the opposition does not allege how she did so, that she knew about or approved them in advance or was otherwise involved in the publication. Boy, it's pretty complicated here, isn't it? Miss Lively is not liable for the alleged Sloan statement because the complaint failed. So they get into the Sloan statement. The complaint includes no facts to suggest that Miss Sloan was Miss Lively's employee. It alleges only that she was Miss Lively's publicist. Oh, well, if you're someone's publicist, you're their employee. It goes on to acknowledge that Miss Sloan is affiliated with a separate PR company, Vision PR, which represents Miss Lively and Mr. Reynolds, amongst others. The complaint also fails to assert factual allegations that Miss Lively played a responsible part or otherwise ratified the Sloan statement. The complaint does not even allege that Miss Lively knew about it, much less that she drafted, approved, or authorized it. Instead, the complaint wrongly credits Miss Sloan as having devised and executed a smear campaign of her own against Baldoni, which, if true, would mean she was not acting under Miss Lively's direction. This, in turn, dooms any idea of ratification and conspiracy. Realizing this, the Wayfair parties instead argue that Miss Lively should have terminated Miss Sloan for making statements that Miss Lively did not and still does not even know she made. That is not enough. The Wayfair parties concede that all causes of action with their gravamen and defamation fail. The opposition does not address and thus accepts that all claims sounding in defamation, whether labeled false light, extortion, breach of covenant, or tortious interference, cannot survive as a matter of law. These alternative theories of recovery are irrelevant and cannot subvert First Amendment protections by artful pleading. Citing no authority, the Wayfair parties attempt to distinguish the false light claim, arguing that under California law, the false light claim is not duplicative of the defamation claim. That is fundamentally incorrect. Because the Wayfair parties fail to show how their false light claim is distinct from defamation and ignore Miss Lively's authority, it must be dismissed. The Wayfair parties still fail to plead the basic elements of extortion. In the opposition, the Wayfair parties identify just two acts they claim support civil extortion. First, they cite an unknown executive's comment that Miss Lively allegedly demanded an apology from Wayfair, Heath, and Baldoni, or the gloves would come off. They do not explain how this amounts to a wrongful threat, nor can they, since the Wayfair parties acknowledge that the alleged requested apology was prompted by Miss Lively's belief that Wayfair, Baldoni, and Heath were waging a shadow campaign against her. Second, the Wayfair party's complaint that Miss Lively allegedly demanded a letter of support for a PJA mark is undermined by their own admission that they were not literally forced to acquiesce, which the opposition completely ignores. These two isolated acts fall woefully short of actions that constitute extortion. Extortion requires an act of duress. Yeah, but I think they'll argue it was extortion because she said she wouldn't get Taylor Swift involved and she wouldn't show up for press. So essentially, she was extorting them by not playing ball. That's what they would say. Recognizing this and that the complaint fails Rule 9b, they argue that the exact contours of civil extortion are ill-defined. This ignores the seminal California case. Worse yet, the Wayfair parties concede that Miss Lively did not acquire money or property through her purported wrongful threats. To save face, they selectively quote from Monnick's deposition co. v. Gilliam and incorrectly claim that acquiring property or money is not required to sustain a claim for civil extortion. But Monnick's ruling on this score is flawed, as recognized by a chorus of authorities that have flatly declined to follow its reasoning. Even still, the Wayfair parties do not cite a single case sustaining an extortion claim where demand for money or property was not made, much less where no money or property was received. Instead, each of their own cases has a demand for money or property, including Monnick's, which involves a $20 million demand. Third, the Wayfair parties do not even attempt to defend their failure to plead damages in connection with this claim, which should be treated as a concession. It follows because the Wayfair parties do not and cannot claim they were deprived of any property, dismissal with prejudice is warranted. Well, I mean, so I guess Blake Lively's saying is that because we didn't ask for any money or property, there's no extortion, but there's clearly an extortion that happened, which is I will not promote the film, which equates to the film will not make as much money unless I get X, Y, and Z. So even if she didn't flatly ask for money, the lack of exchange of services, to finish her job promoting the film would in fact be a monetary amount, right? I mean, what do I know? I know what you're saying. Nothing. By the way, if you guys want to join the Patreon, I'll be live at noon today. noon Central Time, and I've got all my private live streams. There's also a free version of the Patreon where today I posted a radio show that I did yesterday. So if you want to get that, you can go to the free Patreon, patreon.com/Dave Neal, or you can sign up for the bonus community if you want to pay $5 a month if you like what we do. Thanks in advance. Or you could go to my Instagram and follow my, Instagram or TikTok. I got all that content over there. D Neal's on Instagram and TikTok. The Wayfair party's admission doomed the breach of covenant claim. All right, so they get into the covenant claim stuff. I don't find that particularly interesting. Each of the Wayfair party's interference claims fails. So, this is just at the very end. They go, this fails, that fails, this isn't going to work. We already got it all set up, what they're talking about. Because they said Miss Lively is at least vicariously liable for defamation, but neither Miss Lively's, Mr. Reynolds, nor the Sloan Party statements are actionable. So again, we'll have to see what the judge says. I mean, could I be reading this wrong, or could this be one of the more, I don't want to say obvious things, but could there be a higher chance that this is what the judge dismisses, this kind of counterclaim by Baldoni, this $400 million defamation? It seems as though Baldoni has a better defamation case against Ryan Reynolds at this point, doesn't it? The complaint does not plead the existence of a conspiracy. A meeting of the minds to commit a wrongful act is essential to pleading the existence of a conspiracy. The Wayfair parties failed to do so, instead citing irrelevant allegations about a meeting that did not involve any of the alleged co-conspirators. But that meeting has no bearing on whether a conspiracy was formed or that Miss Lively and the other purported co-conspirators understood there to be a conspiracy to harm the Wayfair parties. The Wayfair party's attacks on Section 47.1 fail. After years of promoting themselves as this is where it's going to get good. This is where it gets good, folks. After years of promoting themselves as supporters of women and victims of abuse, Baldoni, Sarowitz, and Heath attack a California statute that was drafted specifically to protect victims from abusers who weaponize defamation law. Contrary to their self-serving contention, Section 47.1 is not a procedural statute. It is a substantive privilege against liability with a fee-shifting and damages provision attached. Both textbook examples of substantive California law that applies in federal diversity actions. The Wayfair party's challenge is likewise without merit. A court in this district rejected a similar challenge, noting the Supreme Court's caution. All right, so they get into this case law, which we don't need to read anything about why they don't think that they've got any case there. Conclusion: all claims against Miss Lively should be dismissed with prejudice and without leave to amend, and the court should award Miss Lively all requested relief. Signed, her attorneys. I mean, look, gosh, it's exhausting. It's exhausting, right? But I'll say this. Again, as like a layman, a guy that, tries his best to digest this but has no idea what the hell they're saying. It sounds like she's got a point that she believed what she said, so therefore there's no defamation. Now, again, maybe if you're a lawyer and you read this, you go, no, they still have a case against her for X, Y, and Z. It seems as though Baldoni definitely has a case against Reynolds. His case against the New York Times, I have no idea what's going to constitute freedom of the press or whatever. In his case against Blake, even though it's clear that the complaint happened and he has all this evidence to kind of refute it, that's going to be important with Blake's lawsuit against him, not so much his lawsuit against her, as far as I'm concerned. Do I have any of this right? What are we even saying? I don't know. So anyhow, that's going to wrap it up for this video. We might have another one right after this. I mean, there's just so much content today. Like I said, I'll be live at noon Central Time to wrap things up. We'll do the afternoon rush hour podcast. If you haven't already, go check out the morning episode. I'm covering, if you enjoy law here, I've been talking a lot about First Amendment, freedom of assembly, protesting, lack of due process, all the things that are going on in our country. And the Supreme Court just ruled 9-0, landslide ruling, that Trump has to return the Maryland-based dude that he sent to a prison in El Salvador. That's a big ruling. I covered that on the morning rush. We'll have more on that and other stuff on the afternoon one. So we'll see you then. Thank you guys so much for the support. Back in a little bit.